termination is concerned, because they were not party, then the other direction to hold a fresh process of selection, terminating the services of the affected person, is not proper. Therefore, staying the said part of the order, the parties may be relegated to before the division bench to raise all the contentions and the grounds which may be directed to be adjudicated in a time-bound manner, looking to the nature of the controversy as involved for the writ court as well as for the writ appellate court. And a council representing the writ petitioners and the state writ petitioners. Council appearing on behalf of the board. Learned Senior Counsel Gupta appearing on behalf of the board. Strenuously asked that the selection was for how many peoples? 32,000.
46,000. Plus sometimes the learned judge is saying 36, sometimes he is saying 32. What is the basis?
Approximately 35,000.
Approximately 35,000. 32. Approximately of 32,000 assistant teachers.
What is the basis? Then nobody knows.
Somewhere it is 36 also.
It is
One
one
single judge is 36.
He has changed that order. He has changed.
Subsequently ordered correct.
Let me declare.
You have changed it on 6th.
You see, you will find the answer of it.
Anyway.
Appears to be more than 30,000 assistant teachers in the untrained. However, to call them and to hold a press interview within the time frame is not possible. In addition, it is a expensive exercise which cannot be possibly done. Full stop. On the other hand, the council appearing on behalf of the writ petitioners contains defended the orders of learned single judge and contains that once the process of selection is found at fault and the interim relief regarding termination of the services of the petitioners have been directed by the writ court, interference may not be warranted in this case. After having heard learned counsel for the parties, without expressing any opinion on the merits of the facts and the legal position as brought to our notice, we are impressed upon only one submission, that the order passed by learned single judge is without joining the petitioners,
Even in a representative capacity.
joining the petitioners as a party, or even in a representative capacity in the proceedings. Full stop. We are further impressed that once the said contention was found merit before the writ appellate court, while granting the partial interim relief, at that stage, issuance of the direction for
Holding press selection.
conducting the selection as directed by learned single judge is not justified. Full stop. Therefore, we set aside therefore, we set aside the interim order to the extent of issuance of the direction to conduct the selection afresh as directed by learned single judge. Full stop. The said order is subject to final outcome of the orders of the writ appeal, orders in the writ appeal. Full stop. We have, as we have already on the cost of repetition, it is made clear here that we have already expressed that we are not considered the merits of the contentions of any of the parties. However, we are at liberty to raise all those contentions before the appellate court, which shall be duly
On its own merits,
considered on its own merit.
including the natural justice. You can raise that it is not required, it is a huge fraud, impossible to raise all that.
All contentions. Before the writ appellate court. List of, considering the fact that it's a matter relating to selection and appointment of the last number of the assistant teachers, we hope and trust that such controversy ought to be decided with an earliest. Therefore, we request the High Court to expedite the writ appeal as expeditiously as possible.
And accept notice, otherwise we will be committing.
The so and so accept notice on behalf of the writ petitioners on the top. Okay, then by consent of the parties, the case is heard.
Item 58, permission to file SLP may be granted. We are item 58.
Why you are not in the writ appeal?
We were not in the rate appeal, but our services were terminated, so we have come here.
Permission.
56, 57.